All right, folks, we're about to get started. Please take a seat. If you are not planning on watching the debate, you could follow your way out. We're getting ready to turn this over to these guys. Let the 11th Cedarville debate round, Cedarville tournament's final round games begin. May the judges be ever in your favor.
In a post-9/11 world, we have come to understand that terrorism is a real threat that we face as Americans. In the 12 years since that brutal attack, our government has taken many effective steps to protect us from an enemy who tries to destroy us and our way of life. In many ways, the federal government has been extremely successful, and thankfully there has not been another attack of that magnitude. However, public privacy comes at a cost, and it is critically important that we not compromise our fundamental beliefs and values in our quest to be safe. As everyone understands, the National Security Agency, or the NSA, is one of the biggest agencies that conduct surveillance. Much like our criminal warrant process, these agencies must follow a court process. This court is called the Foreign Intelligence Surveillance Court, or the FISC. It was created in 1978 under the FISA, or the Foreign Intelligence Surveillance Act, one of the biggest domestic counterterrorism policies ever created. This has spawned the famous amendment that many people refer to, the USA Patriot Act. This court is run by 11 court judges who take turns to individually receive warrants to grant or decline. Unfortunately, this court has one major flaw. It does not uphold the standard that the United States government has set before it. This is why the affirmative team stands resolved. The United States federal government should reform its counterterrorism policies for the domestic surveillance of United States citizens. In order to clarify the round, we present the following definitions. From Oxford English Dictionary of 2014, reform. Make changes in something in order to improve it. Counterterrorism. Political or military activities designed to prevent or thwart terrorism. Policy, a course or principle of action adopted or proposed by a government. Surveillance, close observation, especially of a suspected spy or criminal. Privacy, the state or condition of being free from being observed or disturbed by other people. And domestic, existing or occurring inside a particular country. From Cambridge Dictionary of 2013, a citizen, a person who is a member of a state or country and has legal rights there. From U.S. Legal Dictionary of 2014, the Privacy and Civil Liberties Oversight Board, or the PCLOB. It's an advisory body that assists the U.S. President and executive branch officials with respect to privacy and civil liberties in the implementation of laws, regulations, and policies related to the war against terrorism. The affirmative team will be using the criteria affirmative case structure. Using this structure, we will first present a current goal of the status quo. Next, we will present the harm or the failure, and this will show how the government is not meeting the goal and what needs to be addressed. Third, we will detail a criteria to be used to evaluate whether or not our plan achieves the goal. Next, we will present our plan, showing how we can better accomplish the goal, and finally, we will show the advantages that will come about if our plan is enacted. But first, the goal. From the National Archives and Records Administration, within the subset of the Federal Register, we present Executive Order 12333, United States Intelligence Activities, made on July 31st, 2008, and currently listed as a goal by the NSA on their website. The United States government has a solemn obligation and shall continue in the conduct of intelligence activities under this order to protect fully the legal rights of all United States persons, including their freedoms, civil liberties, and privacy rights guaranteed by federal law. The harm. The Foreign Intelligence Surveillance Court doesn't fully protect Americans' freedoms, civil liberties, and privacy rights. A, there's no legal adversary. From James Robertson, who's a federal district judge who served on the Foreign Intelligence Surveillance Court from 2002 to 2005 in his article of July of 2013. The system is flawed because of its failure to allow legal adversaries to question the government's actions. Anyone who has been a judge will tell you, a judge needs to hear both sides of a case. B, the FISA court does not allow approved warrants to be appealed. From the Alliance for Justice, in their article, President Obama on the FISA Court, More Questions Than Answers, of January 17, 2014. Right now, since only the government appears before the FISA Court, only the government can appeal if it loses. Because the government almost never loses, the court designated to hear appeals has not met in 4 years. By having a broken representation system, the FISA Court is not upholding the goal of protecting our privacy rights as citizens. We will know when the goal has been met through the following criteria: reasonable adversarial representation. The current goal will be met when the FISA Court allows representation for the privacy rights, civil liberties, and freedoms of Americans to be fully considered as surveillance decisions are made. From James G. Carr, a senior federal judge for the Northern District of Ohio and served on the Foreign Intelligence Surveillance Court from 2002 to 2008, in his article of July 2013. Having lawyers challenge novel legal assertions in these secret proceedings would result in better judicial outcomes. Even if the government got its way all or most of the time, the court would have more fully developed its reasons for letting it do so. Which brings us to the plan, the Special Privacy Advocate. Mandate 1, pass sections 902 through 904 and 906 of the USA Freedom Act. These sections create the Office of the Special Advocate. The Privacy and Civil Liberties Oversight Board creates a group of no less than 5 professional law experts from which the Chief Justice will select one to be the advocate. This advocate will be empowered and cleared to sit before the FISA judges and zealously advocate for the privacy rights of United States citizens. If denied access to this court, or if he appeals any past warrant, it is mandatory that he stands as legal adversary before the FISA Court of Review. Agency is the United States federal government, the Office of the Special Advocate, the Foreign Intelligence Surveillance Court, the Chief Justice of the United States, and the Privacy and Civil Liberties Oversight Board. The enforcement is United States federal government, the Foreign Intelligence Surveillance Court, the Chief Justice of the United States, and normal means. Funding is also normal means. By creating and empowering the Office of the Special Advocate, we will meet the criteria of providing adversarial representation. This will fulfill the goal of the status quo by protecting the legal rights of all United States persons, including their freedoms, civil liberties, and privacy rights guaranteed by federal law. We will bring about the following advantages. Advantage 1, civil liberties and privacy are better considered while conducting the NSA's mission. From General Keith Alexander, who is the director of the NSA, as quoted in 2013, as rules and oversight evolve over time, adding a single official who is dedicated to these issues will help us stay on top of changes and bring new perspectives to how we can best consider civil liberties and privacy while conducting our mission. Again, that civil liberties and privacy are better considered while conducting the NSA's mission. Advantage 2, the Special Advocate better balances the interests of liberty and security. From U.S. Senator Richard Blumenthal, who is a Juris Doctor from Yale University, in his congressional address of August 2013. A special advocate would strike a critical balance that serves the interests of both liberty and security. Our government has a legitimate role in protecting us from enemies. However, it has always been an American ideal to have a government that provides checks and balances so there's no ultimate power. The Office of the Special Advocate will align the goals of domestic surveillance by protecting the citizens it serves. As George Washington once said, government is not reason. It is not eloquence. It is force, like fire, a troublesome servant and a fearful master. Never for a moment should it be left to irresponsible action.
Under the definitions, you stated or you presented a acronym, PLCO or
Yeah, the PCLOB,
Okay, and what does that stand for?
the Privacy and Civil Liberties Oversight Board.
Oh, okay. And as for the goal, where did your goal come from? An executive mandate?
Yeah, an executive order.
Okay.
Mhm.
Okay, and your criteria was, correct me if I'm wrong, but reasonable right to privacy and civil liberties, correct?
Almost. It's reasonable adversarial representation.
And what does adversarial mean in that context?
It basically means that within the FISA court, there should be a back and forth discussion on cases that are reasonable to be discussed adversarially.
Okay, so moving down to your plan, you stated What sections of the Freedom Act are you implementing?
902 through 904 and Section 906 of the USA Freedom Act.
Okay, and I heard under Advantage 2 you said special advocate. Is that what part of the Freedom Act implements?
Generally speaking, yes. There are other plans that refer to themselves as special advocates, in this specific context, it's this act that creates it.
Okay, can you define special advocate for me?
It was underneath my mandate. It was kind of long. Do you want me to read the whole thing again or just kind of?
Can you summarize it or
Sure.
Simplify that? perhaps?
Basically, it's like in this debate round, you have the judge and you have the affirmative team. Well, basically, it wouldn't be fair if the affirmative team got up and read their case and then expected the judge to make a decision based off of win or loss. So what we're doing was we're adding the negative team into the FISA court.
Oh, okay. And what was the impact to Advantage 1?
Advantage 1. They're basically saying that the NSA's mission will not be compromised in the slightest by implementing.
What is the tag for that?
Civil liberties and privacy are better considered while conducting the NSA's mission.
Okay, how much more better will they be considered under your plan?
Better than the status quo.
Okay, can you quantify how much more? Like,
It really isn't like a numerical amount, but it's more of a qualitatively significant aspect.
Okay, and under Advantage 2, what was the impact there?
The impact is that there's going to be a balance between security and liberty. So we're not saying that, you know, people should have the ultimate focus on liberty so that we have no security and
So is the special
security.
I'm sorry. So is the special advocate basically a fourth branch of the government?
Not exactly, because it's an office that'd be created under the Privacy and Civil Liberties Oversight Board.
Now, who would oversee the special advocate?
Yeah, that's a good question. So basically, he presents his workings before Congress. I think it's every 2 years.
So basically, Congress would be the one to oversee.
Overseeing him, yes.
Okay. And as for under your plan, did you state that warrants would be able to be better appealed?
Basically, currently in the system, once a warrant has been approved, it can't be appealed. But under the special advocate, he does have the power to appeal an approved warrant.
Okay, thank you then.
Thank you.
The bureaucracy is expanding to meet the growing needs of the bureaucracy. That was said by an unknown author, but it's basically what the affirmative team is trying to do. We have some bureaucratic problems, but the solution is not always to just add another bureaucrat. But before we get into the issues of their case, I'd like to start off with a very important issue of topicality. We don't address this lightly, but when the affirmative team is outside the bounds of the resolution, we feel that this is necessary to give the negative team its fair ground. The resolution says that we must reform a counterterrorism policy for the domestic surveillance of United States citizens. Our topicality press will be an effects topicality press, which basically means that when you look at the mandates in a vacuum, they are not making a change directly within the resolution. Only it affects the policies that we are supposed to be reforming. We'll be arguing this under the definitions of counterterrorism and surveillance. We agree with their definitions. Counterterrorism, to prevent or thwart terrorists, and surveillance, close observation of a person. But if you look at what their mandates are doing, all it is doing is adding a special advocate to something called the FISA court, which is basically a court to decide on national security matters. So here you have an addition to a court, and the court is the one that decides about the actual programs that we're supposed to be debating, like metadata collection and other things like that. The debate policy guidance information talks about effects topicality. It basically says that this sort of challenge occurs when the affirmative team case changes a policy other than the one specified in the resolution, but the effect of the change is not in the topic area of the resolution. It alleges that the affirmative team is not topical in its direct mandate, but only arguably arrives at alleviating harms typically associated with the topic through a variety of internal links. The violations of the links here is that the FISA court is not actually a surveillance program. It's just a court that decides things about that program. There's a difference between that court and the program. The change they're making only changes programs indirectly through something that is not actually part of our counterterrorism surveillance change. They're not changing directly our surveillance of United States citizens or directly any of our counterterrorism programs. The impacts of this is that there's a loss of ground to the negative team and a lack of resolutional integrity and topic-specific educational value. Therefore, we'll be asking for a topicality ruling at the end of the constructives. Before I get into their case structure, I'd like to start with the benefit of the status quo. The benefit of the status quo is the oversight that we have in our current system, which is adequate. According to the Boston Law University Review 2012, in an article by Kim Schliepy and Lawrence S. Rockerfellow, judges have been very active in limiting what the government can do, requiring substantial adjustments of anti-terrorism policy and vindicating the claims of those who have been targets. This goes to show that right now in the status quo, we have adequate judicial oversight of these programs, which are very well managed to avoid any privacy harms. Next, let's look at their goal. Their goal is a good goal, to ensure the legal rights of citizens. But when talking about counterterrorism, they have forgotten one more very important goal of the status quo, and that is to stop terrorists. From the National Security's Strategic Plan 2012-2016, one of their goals is to thwart terrorists. The reason this goal is so important is because if you're dead, you can't feel any gain in privacy. This is something that must come before our expectation of privacy because it's simply a more important matter. Their harm is that there's basically no legal advocate at the FISA court. But the problem with this is it's basically trying to say that the legal rights of US citizens have been violated. This, however, is not the case. According to Rogue Panel Reports on Non-Rogue USA program by Gary Schmidt, the American Enterprise Institute, 2013. As a product of the Snowden materials and the resulting efforts by the NSA, the administration, the congressional intelligence communities, we have learned just how limited in scope the use of the metadata has been and how microscopically the program is managed to avoid just the kinds of abuses that are being brooded about, which have no basis in reality. The affirmative team presented really no impacts to this harm and never gave any examples of anyone who had actually been harmed by a lack of a FISA advocate in their case. Is there anything significant about this harm? The negative contains that there is no significant impact to this harm. Next, let's look at their criteria, which was basically reasonable representation. Reasonable representation is good, but we also have to include other matters in our decision on whether this case is good, including what is its effect on counterterrorism policy and whether it will actually work. So this criteria is not a sufficient weighing mechanism. We pose the counter of criteria is how it is going to affect our counterterrorism policies as a whole. Next, their mandate, which was to put a special private advocate in the FISA court. Now, there are some serious questions about it. At first, it sounds like a great idea. Let's just put someone in there who's going to represent the people all the time. But if you take a closer look at it, it's actually going to bring up some serious disadvantages. According to introducing a public advocate into the Foreign Intelligence Surveillance Act's courts by Andrew Nolan, who is a legislative attorney, the Congressional Research Service 2013. Indeed, as one scholar noted in another context regarding the concept of a public advocate, the institution in itself, in actively opposing the position of a government agent, is so different from the traditional three branches of government that the advocate would be like a fourth branch of government, totally different than anything contemplated by the framers at the time of the ratification of the Constitution, and therefore free of the restraints of the Constitution. This is going to be brought up as a disadvantage later, but basically what it is, it's creating a new fourth branch of government that is not even remotely held accountable to the people. Basically what you're having is one bureaucrat appointing another bureaucrat. So now you have a bunch of levels between the influence of the people that they can have and the actual advocate. So the impact of this is that we have no idea what this advocate is going to do, and that's going to bring up the disadvantages of not being accountable to the public, and also unconstitutionality of this advocate. Next, finally, let's look at their advantage, which There are their advantages, which are better civil liberties and better balance of liberty, which will basically combine into one argument. I'd like to read this piece of evidence here from Secret Surveillance Court Judges Reform Ideas from Ken Dillman, the Los Angeles Times, 2014. The participation of an advocate would neither create a truly adversarial process nor constructively assist the courts in assessing the facts, as the advocate would be unable to communicate with the target or conduct an independent investigation. Adding an advocate to the run-of-the-mill FISA matters would substantially hamper the work of the courts without providing any countervailing benefit in terms of privacy protection. Thank you. I now stand open for cross-examination and clarification.
Good evening, how are you doing?
I'm doing well. How about you?
I'm doing well, thanks for asking. Does the resolution state that the United States federal government should reform surveillance?
It says we should reform our counterterrorism policies for the surveillance of United States citizens.
Okay, but it does say that we should reform counterterrorism policies for domestic surveillance.
That's right.
All right, thank you. What policy are we reforming?
I believe you were reforming, you were adding the USA Freedom Act, which I'm not exactly sure which statute that was reforming.
Okay, so you're not sure whether or not we're reforming counterterrorism policy?
Just by putting a section in the law doesn't mean that you're reforming the actual surveillance policies that we're talking about.
So by changing the policies, we're not reforming the policies? Is that what you're saying?
No, what I'm trying to say is that you can put a section in the Patriot Act that says put cowbells on goats, but that doesn't make it topical. You have to reform something. Yeah, okay. You have to reform something that is actually for the surveillance, counterterrorism surveillance.
Okay. Now, if I steal $10, is that bad?
Yes.
Okay, if I steal $10 from a billionaire, is that bad?
Yes.
All right, thank you. Now, did you read any evidence saying that we're harming security?
Yes, I did read that last piece of evidence. Do you want me to repeat what it said?
No, can you tell me where you read that?
Yes, it was the last piece of evidence I read in my speech.
Underneath the advantage? Okay.
The advantages, yes.
Under the evidence that you read underneath the harm, did that piece of evidence mention the FISA court at all?
It was talking about the NSA programs which the FISA court is affecting.
Okay, so it's talking about the NSA agency, not specifically the FISA court agency.
That's correct.
Okay, thank you. Did you read any evidence underneath either of your disadvantages?
That will be brought up by my partner in his next speech.
Okay. Now, you were saying that underneath our goal, or no, sorry, underneath our harm, that we haven't given you any instances of where it's been an impactful violation. Is that correct?
Yeah, where someone has been physically harmed by these programs.
Okay, so then why is it bad that if I take $10 from a billionaire, that doesn't really physically impact him, yet you still say that that's bad?
Right. It would not be worth it to spend, say, $1 billion to prevent someone from taking $10 from a millionaire.
Right, so you're saying, basically what you're saying is that the quality of the law is worth upholding.
Basically what I'm saying is for something that really has no impact, change is not worth making.
Even if it's breaking the law?
Even, for instance, the $10. I mean, how much are you going to spend to save that $10? At some point, it doesn't become worth it.
Okay, what is that point?
I would not like to give a technical distinction right now.
Okay.
Actually, if you were going to spend $10 to save $10, that might be good.
That's really deep. Thank you.
Yeah, okay.
Quote, the FISA court operates in near total secrecy and only hears from one side, the U.S. government. What's more, it's gutted the Fourth Amendment by creating expansive exceptions to the law unseen before in any other court. That's from Mark J. Cox, a legislative analyst who specializes in privacy, civil liberties, and surveillance, in his article, How to Reform the FISA Court, August 14th, 2013. Because of the abuses that the FISA Court has made to the Constitution, we as the affirmative team advocate for reform. First of all, in this speech, I'd like to address the important issue of topicality and show you how we, as the affirmative team, are giving the negative team fair ground and we are within the bounds of the resolution. Now, the negative team said that we are affecting but not changing the policy identified in the resolution. But I'd like to show you that how we as the affirmative team are changing the policy defined by the resolution. The resolution doesn't actually say the affirmative team must reform domestic surveillance. The resolution says that the affirmative team must reform counterterrorism policy for domestic surveillance. And that little word "for" is easy to miss. So read the resolution like this. The affirmative team must reform counterterrorism policy for or intended to belong to domestic surveillance. The affirmative team is amending the Foreign Intelligence Surveillance Act, which is a United States counterterrorism policy, as the negative team said in Cross X. Now, we are reforming a policy from we are reforming a counterterrorism policy that is intended to be used with domestic surveillance. The FISA court is intended to be used with domestic surveillance. Domestic surveillance in the United States only occurs through a warrant process. That warrant must go through the FISA court. So you see that we are reforming policy, counterterrorism policy, for the domestic surveillance of U.S. citizens. We are within the bounds of the resolution. Moving on to the rest of the case. Now, the negative team brought up a status quo advantage, first of all, that there is sufficient oversight in U.S. courts, and that the NSA has sufficient oversight. However, as I read from Mark J. Cox, a legislative analyst, the FISA court has gutted the Fourth Amendment. U.S. Senator Richard Blumenthal, in the article "The FISA Court Secrecy Must End," July 14, 2013, explains more exactly the abuses of the court. He says that the FISA court serves a critical purpose in our national security apparatus, ensuring timely consideration of surveillance requests when seconds matter most. But the court in its current form, unaccountable, secretive, one-sided, is broken. It not only lacks any genuine accountability, it also deprives the entire system of trust and credibility in the eyes of the American people. The executive branch has now confirmed that the rules, regulations, and court-imposed standards for protecting the privacy of Americans have been violated by this court thousands of times each year. He goes on to say that these violations of the laws and rules were more serious than had been acknowledged, and we believe Americans should know that this confirmation is just the tip of a larger iceberg. This plays directly into the harm that the FISA court doesn't protect your legal rights. The government is under a solemn obligation, as our goal states, to protect the legal rights of U.S. citizens, including freedoms, civil liberties, and privacy rights. But it's simply not doing that in the status quo. The negative team brought up a counter goal, stating that a more important goal would be to stop terrorists. But the affirmative team's plan does not hinder counterterrorism policies. The affirmative team's plan allows counterterrorism investigations to continue while better considering civil liberties and privacy. The director of the NSA attests to this fact, and the director of the NSA has a very strong incentive to do his job, and by saying that having a special advocate on the FISA court will not hinder the NSA's mission, you can take that as a pretty credible source. So I've already gone through the goal and the harm. Now, under the harm, the negative team said that the NSA doesn't misuse metadata, essentially is what they were saying. But they didn't directly clash with our harm. What we're saying in the harm is that the FISA court is violating the Constitution, and because of the way it's set up, it's not an adequate process as defined by the Constitution, as courts were intended to be set up, with a back and forth that you're receiving in this debate round. Moving on to the plan. Or first, the criteria, that of reasonable adversarial representation. Now, in a moment, when we get to the advantages, I'd like to explain why we included the word reasonable under the criteria. But for now, just know that this is our criteria. It will work, and it does change counterterrorism policy to have adversarial representation on the Counterterrorism Court of the United States. Moving on to the mandate. The mandate is to pass these sections from the Freedom Act. The negative team brought up two disadvantages under the mandate. The first was saying that the advocate would be like a fourth branch of government, and that the advocate isn't constitutional. Now, the evidence that they read said that the advocate would essentially be free from responsibility. So that's really three different things that they identified there. But the advocate wouldn't be free of responsibility. He must defend the Constitution. He will be reviewed by Congress, as my partner pointed out. Also, on the unconstitutionality issue, special advocates have served in custody court for years without being challenged from a constitutional standpoint. And so advocates on the FISA court will have no issues constitutionally because there's already the legal practice instituted in other areas of United States courts. So we can see that these are not issues. Moving on to the advantages, the results of our plan. The first advantage is that civil liberties and privacies would be better considered while the NSA is conducting its mission. Now, the negative team brought up a piece of evidence saying that the advocate wouldn't be helpful in the court if he appeared in run-of-the-mill FISA proceedings. That's true. That's why we included the word reasonable in our criteria, to ensure that the advocate didn't appear before run-of-the-mill FISA proceedings, but that he only appeared when the court is making novel legal interpretations. Thus, the special advocate will appear when he's needed, and he won't appear when he's not. Thereby, he will be effective, and he won't hamper any counterterrorism investigations. I'd like to take a moment and read a piece of evidence from James Carr, who is a senior federal judge for the Northern District of Ohio and who served on the Foreign Intelligence Surveillance Court from 2002 to 2008. He says that during my 6 years on the FISA court, there were several occasions when I and other judges faced issues none of us had encountered before. A staff of lawyers assist the court, but their help was not always enough given the complexity of the issues. He goes on to say that having lawyers challenge novel legal assertions in FISA court proceedings would result in better judicial outcomes. So we can see from this piece of evidence that a judge who is on the court advocates for having this position in order to help them make novel legal interpretations. The special advocate would be effective and not result in the disadvantages that the negative team may claim. So in this speech, I've showed you not only how we fit within the bounds of the resolution, but we offer a plan for change that is viable and that protects your privacy as American citizens.
Now, does the FISA court itself do surveillance?
The FISA court doesn't do surveillance, but it is intended to be used for or with surveillance.
Okay, did you define for in your case?
Right, intended to belong to.
Intended to belong to?
Yes.
Okay, now, the FISA court, does that intend to belong to the surveillance of the United States citizens?
It does.
Okay, how would you say belonging? What does that mean exactly?
Well, basically it belongs to surveillance in the sense that it belongs to the process that determines surveillance.
Okay, so basically it belongs to, your change you're making belongs to the process of surveillance.
Yes.
Okay. Did you really define for in your case? I missed that, okay. Did you?
Not in our case, but
Oh, you
in
did?
my speech.
That's what I'm missing, okay. Got it, okay. Now, did you address our benefit of the status quo?
I did.
Okay. Next, how long can court cases take?
Well, it depends on what kind of court, but normally the FISA court cases don't take that long.
Okay, could a reason for that be is that they don't have two lawyers arguing back and forth?
That's part of it, yes.
Okay, so would adding a lawyer to always take the other side perhaps add some more time to what this court takes?
It would add some more time, but the benefit is worth that small amount of time added to the process.
Okay. Now, wherein you mentioned that your advocate would only be helping in reasonable cases. Where in your mandate did you say that?
So basically the mandate says that we pass these sections of the law, and the law delineates that there are 3 ways in which the advocate can appear before the court. First, the court can ask the advocate to appear before a case. Second, the advocate himself can ask to appear before the case, and the judges have the authority to determine whether or not he will. And third, he can appeal a warrant that has been approved and come before the FISA court of review.
Okay, now what is to prevent the lawyer from requesting to be in every single court proceeding?
He can request that, but the judges have the final say in determining whether or not the advocate will appear before a specific case.
And what's to prevent the advocate from appealing every single case?
Well, the fact that he wants to keep his job and he is reviewed by the people's representatives in Congress.
Who is he reviewed by? What, didn't you say he was reviewed by the Chief Justice?
He is appointed by the Chief Justice. He is
Okay, who's the
reviewed-
Chief Justice appointed by?
The Chief Justice is appointed by the President.
Okay, so the people somehow hold him accountable through the election of the president, then the appointment of the Chief Justice, and then the appointment of the special advocate?
It's more direct than that. Congress itself reviews this man's job performance.
I'm out of time, thank you.
Decisions had been and continue to be made by the executive, the Congress, and the courts, acting in accordance with their constitutional responsibilities and the authorities we the people have entrusted to them. From the article, What It Takes in Defense of the NSA by Michelle Van Cleve, December 2013, the World Affairs Institute. Now, this is the negative philosophy in this round, is that there's a lot of accountability that already takes the place of any unneeded special prosecutor, and that this current oversight is sufficient, and therefore there's no need to adapt the affirmative team's plan. So without further ado, let us dive right into the stock issue of topicality. Now, topicality, we're running affects topicality, and the standard is the resolution, which is resolved, the United States federal government should reform its counterterrorism policies for the domestic surveillance of U.S. citizens. Now, we're actually going to be counter-defining for from Merriam-Webster's, which is for the purpose of. Now, if you listen, now according to the resolution, there is the surveillance for the domestic surveillance of U.S. citizens. It should be for the purpose of. The definition of whatever by the affirmative team, that which belongs to surveillance, is just too broad for this resolution, because the definition for the purpose of more closely fits with the context of the resolution. Now, let's see. Now, the special advocate is, as the affirmative team, well, as the negative team would state, is that it's really a fourth branch of government. It oversees the FISA court and attempts to increase privacy somehow. Yet, this is, again, this does not match the definition of what it means to, the special advocate isn't actually watching somebody. And I believe the affirmative team did define surveillance as close watch kept over someone or something. Now, it's important to understand that these special advocates don't actually fulfill that definition as stated by Merriam-Webster's, that it's not actually, the special advocate is only attempting to oversee, not actually surveil U.S. citizens, nor is it a counterterrorism policy. That's also key. It's just an oversight policy. Now, the negative team stated that pretty much that the FISA court is used with surveillance, but the thing that breaks that is the definition of for the purpose of. So now let us move on to the benefit of the status quo. It is that the current status quo is accountable. Now, let's see. Okay. According to Michelle Van Cleve, What It Takes, previously cited, accountability and unparalleled openness to public scrutiny and the rigorous oversight of the political process is the unique quality of U.S. intelligence. The fact that we measure these things against civil liberties and bring them under the careful checks and balances of our Constitution is the bedrock of their strength. Now, this is in support of the status quo, that the current system already has adequate oversight, and that is, we would actually lose that in disadvantages, as I will point out in a moment, with the affirmative team's plan. So now let us look at the criteria. The criteria, we're basically, the negative team is adding we're basically stating that this criteria should also consider its impact on counterterrorism efforts. Now, in a disadvantage 3, that is delayed action, which would hurt our ability, our security for this country. And the goals. Now, the goal was to reasonably increase privacy. And, wait, no, it was from a executive order. Excuse me, that was the criteria. Sorry. As I will show, there is no impact to this increase in privacy. Now, the harm is that the FISA court doesn't protect privacy and civil liberties. Now, according to Brian Walsh and Todd Gazzano, October 2007, the Heritage Foundation, modernize FISA but don't hobble American intelligence operations, states, privacy absolutists have to date been unable to point out any actual harm that individual Americans have suffered because of the information collected as a part of the foreign intelligence program since 9/11. They can point to no Americans who have been convicted unjustly or even prosecuted unjustly based on information obtained through these terrorist surveillance programs in violation of their statutory or constitutional rights. Now, again, there is no impact to an increase in privacy. This flip side of this harm is the advantages, which is an increase in privacy and civil liberties, as well as special advocates provide more accountability. But there is no impact because the affirmative team can't tell us how much more privacy they will receive under this plan. And now we can look at the plan specifically where the disadvantages lie. Now, the first disadvantage is that of no accountability. And as my partner read evidence stating, there's simply, it's like a fourth branch of government, and therefore the impact to that is basically a lack of accountability, which is the inverse of what the affirmative team would want you to believe. Disadvantage two is that of free of restraint, and the impact is, we don't know what he will do, what choices he will make, and this just creates a constitutional issue because it's like having a fourth branch of government over, he can do pretty much whatever he would want to do. Now, according to Blank Check, Ethics in Government, The Price of Good Intentions, Linda Greenhouse, February 1998, The New York Times. I'd like to point out that this piece of evidence is still relevant because the nature of these special advocates hasn't changed. Therefore, the evidence is still applicable. And I quote, an independent counsel or independent special prosecutor finding the truth is a misconception of the job, which is really to decide whether this is a kind of case that would be prosecuted if the person were not a high-level official. If it is not such a case, then the independent counsel's mission is complete even if the result is uncertainty rather than truth. So now, if the goal of the special advocate is to get to the truth, which is that of privacy and civil liberties, that's not necessarily the goal of a special advocate. This goal of a special advocate could turn out to, as my partner stated, he could be abusive and he could result in what is disadvantage 3, delayed action. Now, delayed action is dangerous for our country because we need our security measures in the shape that they are in currently, and therefore we can't let efficiency suffer. I'd like to reference the cross-ex that just occurred, which in the example of the third lawyer in a debate in a courtroom would, as the affirmative team stated, just add time to the court case. So it's going to delay this entire process, which is certainly what we don't need, especially when there is simply no example of privacy violations like jail time or that kind of thing given by the NSA. So, and under the advantages, basically the point is that adding special advocates would hamper the courts. That is the argument there. So for these reasons, I am open for cross-examination and clarification.
Good evening.
Yes, good evening. Good evening.
Are we amending the Foreign Intelligence Surveillance Act?
I believe you are.
Okay. And is that act counterterrorism policy?
I believe it's counterterrorism policy, but you're adding oversight to that policy.
Okay. Where do you get a warrant for the purpose of surveillance?
I believe warrants attained, such as under the wiretapping program, would be attained via some sort of judge.
Okay.
Not sure what level.
Okay. Why does the FISA court exist?
The FISA court exists, I believe its inception was, it might have been earlier than the Patriot Act, but its purpose is to, its intended purpose is like that of metadata collection and wiretapping to protect Americans.
Okay. Under your first disadvantage, why is a special advocate a fourth branch of government?
Well, because there's no, even though there may be some sort of congressional accountability, there's no particular, if a special advocate's purpose is to somehow enforce privacy, I believe it is, then there's no reason to believe that he will not become abusive himself, because Congress, there was an example of, I believe, there's a special advocate for politicians in the past, and it hasn't always worked out so well.
Okay, we may come back to that. What was your second disadvantage?
Our second disadvantage is that of a lack of loss of constitutionality through basically these special advocates they're basically free of restraint,
Okay, and
as stated by evidence.
your first was that he would have no accountability.
Yes.
Okay, so how are those two disadvantages different?
Well, first, as my partner read evidence stating, there is simply no accountability for the special advocate, and disadvantage two is that he is free of, basically, it's unconstitutional because there's no restraint, as my partner read evidence stating.
Okay. Do you agree with your partner that it's bad to steal $10 from a billionaire?
In a values debate, I believe that it's wrong to steal money in general.
Okay, why is it wrong to steal money in general?
Because I'd rather work for that money myself.
Okay, thank you. No further questions.
Topicality will go to the affirmative team. The round will continue.
In the first negative rebuttal, I will be organizing all the arguments in the round down into 6 key issues, or 6 fatal flaws with the affirmative team's case. The first will be under the stock issue of inherency, the second under significance, and the remaining 4 under the stock issue of solvency. Keeping in mind that our goal is to thwart terrorists along with protecting privacy, and that the criteria should be judged on the overall effect on counterterrorism and not just on one aspect of it. Let's begin with fatal flaw 1 under inherency, and that is our benefit of the status quo, that we have adequate current oversight. As I read previously, judges have been very active in regulating the NSA's programs, and there's no lack of court oversight of these programs. According to the Patriot Act and the Constitution, 5 key points, the Heritage Foundation, 2011 by Jenna McNeil. These tools come with significant procedural safeguards, oversight, and reporting requirements, and are subject to routine and aggressive oversight by the FISA Court and Congress. There is no inherent need to establish a new special advocate. Fatal flaw number 2 is that of significance under the first harm, and that is that there is no actual harm to privacy, or to anything else, really. According to Brian Walsh and Todd Gazzanazzo, 2007 Heritage Foundation, modernized FISA but don't hobble it. Privacy absolutionists have been unable to point to any actual harm that individual Americans have suffered because of information as part of the terrorist surveillance program and similar foreign intelligence programs. In other words, there is no actual significant harm, meaning that the impact of the harm is basically non-existent because it's not causing any significant impact to anyone. Therefore, there is no significant reason to pass their case. Fatal flaw number 3, it falls under the stock issue of solvency under advantage 1, is basically, will the advocate actually help anything? According to Introducing a Public Advocate into the FISA Court, Relevant Legal Issues, Andrew Nolan is previously cited from the Congressional Research Service. Some commentators have questioned whether the judicial power which extends to cases or controversies allows the government through the National Security Division of the Department of Justice and the newly created public advocate to literally argue both sides of a legal case, which casts doubt on whether the court would be truly overseeing a contested decision. In other words, would adding a public advocate actually help? As this evidence says, probably not. Next, we have fatal flaw number 4, and that is that of disadvantage 1, that the special advocate is unaccountable to the public through a long chain of appointments that basically makes this an extremely bureaucratic position that is not held accountable to the people. While it's supposed to have the people's interests at heart, we don't know really what's actually going to happen. Things get dangerous when you take bureaucracy way too far and start making additional bureaucracy to start regulating the bureaucracy. Really, it should be regulated by the Congress and the court oversight that we have right now. Next, we have fatal flaw number 5, and that is that the special advocate is not questionably constitutional. According to the same article from the Congressional Research Service, Article 3 of the Constitution, which vests the judicial power in the United States in the Supreme Court and any inferior courts created by Congress, also poses some significant legal questions with respects to proposals creating a FISA public advocate. As we read evidence previously, the doubts about creating a whole new fourth branch of government poses some serious constitutional issues. Basically, this would be free from any restraints by the Constitution, and the impact of this is that we have a loss of constitutionality, which the affirmative team is trying to gain. Instead, they're going to be negating the constitutionality. And so, instead of helping, their case is actually going to be hurting. Finally, under fatal flaw number 6, we have that it will hamper the courts. As I read previously, adding an advocate to FISA matters would substantially hamper the work of the court without providing any countervailing benefit in terms of privacy protection. Basically, if we add a lawyer to argue the case, that can take a lot of time. Sometimes legal cases don't get decided very quickly. And in important national security matters, it's absolutely essential that these cases be decided quickly. The impact of this is increased terrorism and more death to American citizens. Thank you, and I urge for a negative ballot.
As the great philosopher Voltaire once said, a witty quote proves nothing. So with that, let's get into the case and start with the stock issues. First, with the point under inherency. And the main point of contention with the negative team is that the benefit of the status quo is that there is oversight. Now, there's a couple points under this. First, if you carefully look at their evidence, the evidence that they're talking about is oversight over a specific agency of surveillance. And that agency is the NSA. Now, this is a completely different agency than the FISA court. The NSA is the one that actually conducts the surveillance. The FISA court is the person that approves that surveillance. Now, the FISA court also has to deal with any other surveillance agency that would come before it requesting a warrant. So that piece of evidence has pulled their harm out of context and tried to stick it to our case, even though they're talking about a completely different agency than the one that we're talking about. But for peace of mind, let me read this piece of evidence from James G. Carr, who was a former judge on the FISA court. The most credible person that can talk about the FISA court is someone who has judged on the FISA court. Now, from this article of July of 2013, he says, one obvious objection. Judges considering whether to issue an ordinary search warrant hear only from the government. Why is this not to be same when the government goes to the Foreign Intelligence Surveillance Court? His answer, although lengthy, points to the fact that there's a difference between this kind of oversight. He says, for an ordinary search warrant, the judge has a large and well-developed body of precedent. When a warrant has been issued and executed, the subject knows immediately. Now, he goes on in the article to compare that to the FISA court. And he says, once a subject has been granted a warrant to be surveilled, that subject is never notified unless indicted. Now, what that means is that he won't be notified that he's being surveilled until he's going to court for the crime that he committed, or the crime that he didn't commit, which points to the aspect of our harm and the aspect of significance. Under the second point, they say that there's no harm to privacy. Now, first of all, there's actually a contradiction made by the negative team. If you look at their disadvantage having to do with unconstitutionality, they say in our harm that breaking the law is not significant in any quantitative way, but under their disadvantage, unconstitutionality underneath our plan does apply in a quantitative significant way. When really the issue is that the government is breaking the law. And as both teams agree, breaking the law is wrong and is bad. It's not bad in necessarily a quantitative way, even though the status quo points to leading down that range. And we even have evidence here from a judge that quit his job on the FISA court because it was heading down towards quantitative significant harm. But the problem here is that we as Americans have a high qualitative standard for upholding the law. That's why we punish people when they break the law. Now, under our harm, we're punishing the FISA court for breaking the law. We're adding more oversight and a person that has the experience of a professional lawing aspect to come and help these judges as they make constitutional decisions. Now, moving into the issue of solvency, he says that they ask the question, will it actually help? will actually help these judges. Now, we've given you a piece of evidence from 3 different judges who have all said that in the time while they were judging, it would have been incredibly helpful to have someone who could have helped them work through the constitutional issues. For instance, the issue of metadata collection. And what we see here is that our special advocate won't be dealing with the run-of-the-mill cases as the negative team will have you believe. Instead, it's these novel legal interpretations that these FISA judges aren't equipped to make. And they explicitly state that in articles that they have posted. Now, for the 4th one, they say that the disadvantage comes from unaccountability to the public. But under our plan, if you read carefully the text that we're passing, this special advocate must report to Congress. Now, the Congress, as we all know, the government is the people. People elect these congressional representatives based off of how they make decisions. Now, one of these decisions is what they will do with the special advocate. So not only is it not a problem to not disclose everything to the public, but things are going to be disclosed to Congress, and Congress will have oversight over the special advocate. Under the point 5 and 6, we're going to see that the director of the NSA himself has said that this special advocate will help security and not hinder their mission. And I'd just like to say that if we were the ones that were being subject to surveillance, we would want the FISA court to take a long time to make sure that we are actually terrorists. Because I know that I'm not a terrorist. And if I was ever in that seat, I would want someone to represent me. In the current system, no one does.
This round has come down to the 3 stock issues of inherency, significance, and solvency. And I will show you how each of these stock issues goes to the negative team and why the affirmative team's plan should not be implemented. To start off with inherency, that is the harm of the affirmative team's plan, and the negative team stance is that there is routine oversight. Now, I'd like to point out that despite the fact that some of our evidence was relating to the NSA, some of it was also relating to the FISA court as well. So it's not, there's no blanket statement that should be made over the negative team's evidence stating that all of it just came or referenced the NSA. So the argument posed by the affirmative team then, therefore, is that special prosecutors will add needed oversight. Yet, as we pointed out, there's already adequate oversight, and the disadvantages of less basically no accountability and that of free of restraint would basically limit the benefit that the United States would get from these special prosecutors. Now for significance. The affirmative team stated that, well, this is a matter of basically who's being harmed or who is being affected by this lack of privacy, or these, like the FISA court, which is then in turn these surveillance programs. Now I'd like to point out that the evidence I read earlier from the Heritage Foundation, Modernize FISA but Don't Hobble American Intelligence Operations, stated that there's simply, the evidence basically stated that no privacy absolutist can, to date, point out any actual harm an individual has suffered, such as jail time, being jailed or death by a lack of privacy. So that's the kind of qualitative significance that can be shown, is that simply there is no impact to this alleged lack of privacy. Now on the flip side, which I will get to under the solvency points of constitutionality, basically it's adding a 4th branch of government. That's what the special advocate is. And I'll get there in just a moment. Now let's move on to the stock issues, the points under solvency, which constitute numbers 3, 4, 5, and 6. Under number 3, the argument here by the negative team is that adding a special advocate would not help. Now, as the affirmative team even stated in Cross-X, having someone, and if I understand this correctly, a special advocate will somehow give, speak with the judge during a trial or something of that sort and put his input into it. And the idea here is, well, even though he's overseen by Congress on, say, a monthly basis, or maybe it's a half-a-year basis or whatever it is, he can still make poor decisions in the court. And therefore, there's no benefit to adding a special advocate. Under point number 4, solvency, the argument here is that an addition, it's like adding additional bureaucrats to the system, and this is simply not needed. As stated by prospects of having permanent special prosecutors seen unlikely by Observer Reporter, Associated Press, July 1974. Quote, Cox, the first special Watergate prosecutor, said the primary responsibility for preventing and exposing wrongdoing high in the executive branch lies with the president, and he should not be relieved of this responsibility or the consequences not fulfilling it. In addition, it states, establishing a permanent office of a special prosecutor, he testified, would dilute this responsibility and be a grave mistake. So there's simply, this is a rather large drawback of the affirmative team's case, that even way back in 1974, when special prosecutors were attempted, there's still damage done through this fourth branch of government system. Under point number 5, that is that of special advocates are free from constraint, and it's mandated by the affirmative team. Yet I'd like to point out that basically, again, however often he's interviewed by Congress is not dependent on what kind of decisions he'll make inside a trial. And point number 6 is that of adding prosecutors would basically delay our national security response time. And now the affirmative team stated that we want FISA to take our time, but again, this goes back to the impact of privacy. Has anyone been hurt? Not according to the affirmative team has not been able to show us any example where somebody's been jailed unjustly and that sort of thing, has died from a lack of privacy. So for the reasons of inherency, solvency, and significance, I urge for an negative ballot.
There's no doubt that the secret court overseeing the unconstitutional NSA spying must be reformed. The recent revelations of large-scale domestic surveillance approved by the Foreign Intelligence Surveillance Court are proof of that. From Mark J. Cox, as previously cited. There is great reason to reform the status quo. In this speech, I'd like to show you why the affirmative team's plan is necessary in order to promote the privacy and security of United States citizens. First of all, under inherency. Can the status quo and will the status quo fix the problem without the affirmative team? The negative team would have you believe that it has or that it will, because there is already effective oversight of the FISA court. But there isn't oversight of the FISA court. Until recently, we didn't know about many of the decisions that the FISA court made. They were leaked to us by Edward Snowden. There are many decisions of the court that are still unknown to both you and I and members of Congress. Congress should be able to know what's going on in the FISA court. The special advocate would provide for that. And the FISA court should be overseen by the special advocate in order to ensure that this court doesn't become the ultimate authority on whether or not warrants are approved or not. So we see that there is a harm in the status quo and that the status quo cannot fix it by itself. It needs the affirmative team's plan. Moving on to significance. Now, the negative team has said, who's being harmed? What's the real risk with the FISA court? Well, who's being harmed is you. You are represented by the Constitution. However, the Constitution is not being upheld in the FISA court. There are instances where the FISA court doesn't uphold what it's supposed to, the constitutional rule of law. And the FISA court puts the U.S. in the direction of violating the Fourth Amendment. And while there may not be large-scale numbers now, the fact that the government is breaking the law is enough to change, and that it's in the direction of continuing to break that law, it clearly needs to be reformed. The negative team quoted a piece of evidence from the Heritage Foundation in making this argument, but I'd like to point out that the Heritage Foundation actually would like for a special advocate to appear before the FISA court. It's in favor of it because the government is breaking the law. So we can see that there is a significant reason to change because the FISA court doesn't protect rights. I'd like to point out that the negative team has not addressed the fact that under the status quo, approved warrants cannot be appealed. By passing the affirmative team's plan, approved warrants will be able to be appealed, which will allow the special advocate to appeal the court's decisions, thus making the court's decisions not the final authority. Moving on to the issue of whether or not the special advocate would be effective. The special advocate would be effective because he would enable the court to make better decisions. These are not my words. These come from 3 different judges who have served on the court: James Carr, James Robertson, and a judge who currently serves on the court who chose to remain anonymous. So we see from these judges that a special advocate would be effective. The negative team in their last speech said that the special advocate can make poor decisions. Now, this is a new argument and should not be allowed to stand in this debate round because it had its origin in the 2NR. Moving on to solvency. The first solvency point was that we're simply creating more bureaucrats, and it's not really going to help. Now, under this, they quoted a piece of evidence from the Associated Press from 1974, before the FISA court was even created. So this evidence doesn't apply to our case, obviously. But the special advocate would be more than just another bureaucrat. He would be someone who has a vested interest in protecting your privacy on the FISA court. The next point under solvency is that the special advocate would be free from all restraint. This is simply not true. The special advocate has an incentive to do his job because it's written into the text of the law that we're passing that he will be a zealous and effective advocate for civil liberties. And so he, by being accountable to Congress, will have a great incentive to do his job. The final issue is that the special advocate would delay counterterrorism investigations. But this has not been proven by the burden of rejoinder of the negative team that it would delay it by any significant amount. The negative team didn't bring up any evidence to support this point, and the special advocate would not significantly delay the time it takes to get a warrant, but he would significantly improve the process. As George Washington said, government is not reason, it is not eloquence, it is force, like fire, a troublesome servant and a fearful master. Never for a moment should it be left to irresponsible action.